Ladies and gentlemen, good evening. May I kindly ask that you move closer to the front of the auditorium, please, if you be so minded. There are under each of those front chairs a gift redeemable at Island Luck. I was a young reporter in 1970-something at ZNS, and one of my first assignments was to cover Dr. Doris Johnson, late. And she was, as many of you may know, a woman of outstanding elegance. And we were in a sitting like this, and she said, "May you repair yourselves to more commodious surroundings," meaning to come forward. Nevertheless, good evening. Thank you so much for being a part of our program this evening. The Bahamas Bar Association and the Council of Legal Education and the Eugene Dupuch Law School's public forum on the subject, the death penalty, the worst of the worst. It is my honor and privilege now to welcome the President of the Bar Association, Dr. the Honorable Khalil Parker.
Thank you for that, Jeff. Your check is in the mail. Good evening, everybody. Good evening. Thank you for attending this evening. The Bahamas Bar Association and the Eugene Dupuch Law School are quite pleased to put on this public forum for you. We believe that it is fundamental to the mission of both the Bar Association and the law school to express a commitment and demonstrate a commitment to public engagement on issues of public importance. And I'm very proud to see my members and our international colleague here to offer their perspectives and experience on issues that Bahamians contend with as we tackle the broader issue of crime and the solutions to crime and the potential options available to us. I know that the old adage is on the book, we got to do it. And so it is useful for us to engage in these exercises where you get to hear from the bar and from the law school perspective so that you can be empowered to engage with your own private debates. And we also want you to take full advantage of the microphones that you see in the middle. We want to hear from you. And your presence here is a demonstration of your interest in the dialogue that we hope will advance our national discussion more broadly. So sit back, relax, and enjoy. I would like to thank our distinguished host for his warm introduction and his service tonight. Mr. Lloyd is no stranger to any of us. I'm sure that he will facilitate a very engaging dialogue with your panelists. Thank you.
Thank you again, Mr. Parker. You know, ladies and gentlemen, the issue of the worst, or the rarest of the rare, came into the lexicon of Bahamians in 2011. And that was when the Bahamas found itself in a state of surprise and bewilderment at the Privy Council's ruling in the case of Max Tito versus the Queen. Because the citizens of this country, from the judiciary to the ordinary man on the street, was left with a jaw-dropping motion. The worst of the worst and the rarest of the rare in that case. The application to which those words were to be used spurred a distaste and a call for action from many social quarters. So we are pleased to welcome you this evening. And as the President indicated, we wish that you would please find yourselves into a proper engagement with our distinguished panel. We have established and erected 2 microphones. They are in the center aisle. The presentations will all be completed, and then with a raise of your hand or presenting yourself at the microphone, state your name. You may wish to identify from where you come and direct your questions specifically to one of our presenters. So that will again come at the very end of our presentation. I would like to kindly ask you at the very end of my introduction to then welcome our presenters. We have visiting from the Bar of Ireland, and please forgive me, Professor, that I pronounce this properly, Professor Carsten Zachler. Please welcome him. We have Mr. Damien Gomez, KC. Please welcome him. Didn't follow my directions. Mr. Reynard Henfield. Please welcome him. And Mrs. Ty Pinder Mackey, our presenters. Please welcome them. Ladies and gentlemen, we begin our presentation this evening with a lecture, as it were, by Mr. Damien Gomez, KC. Please welcome him.
Good night, everyone. Forgive my raspiness, but I've just been getting over a flu that has gripped me for the last 7 days. But don't be afraid, I'm not infectious. My doctor gave me the liberty to join you this afternoon. At one point, didn't think I would be able to, and out of an abundance of caution, prepared a text which I had invited my erstwhile junior, Mrs. Mackey, to read if the worst came to the worst. And my address is entitled, The Death Penalty Implications, State versus Koirati, 2006, 2 weekly law reports, 1330, speaking note. In recent times, the recurrent increase in the incidence of murder and crimes of violence has shocked our communities. A sense of insecurity has wrapped around the collective horror confronting us. In a sense, we are challenged to embrace our values, or alternatively, to abandon them in exchange for an illusory security. It is now settled law in the Bahamas that the imposition of the death penalty is the subject of judicial discretion. And that is established by Maxwell Tito versus the Crown. It's the Privy Council decision number 3 of 2010. And the specific paragraphs are paragraphs 33 to 38, which deal with the sentencing. The unanimous decision of the board was delivered by Lord Carr, who cited and followed Trimmingham and the Crown, another Caribbean case, 2009 UKPC at page 25, and Pipersburg and the Crown, 2008 UKPC at page 11. Quoting Lord Carswell in Trimmingham, and I quote, "Judges in the Caribbean courts have in the past few years set out the approach which a sentencing judge should follow in a case where the imposition of the death sentence is discretionary. This approach should be regarded as established law. It can be expressed in two basic principles. The death penalty should be imposed only in cases which, on the facts of the offense, are the most extreme and exceptional. In considering whether a particular case falls into that category, the judge should compare it with other murder cases and not with ordinary civilized behavior. The second principle is that there must be no reasonable prospect of reform of the offender, and that the object of punishment could not be achieved by any means other than the ultimate sentence of death. The character of the offender and any other relevant circumstances are to be taken into account insofar as they may operate in his favor by way of mitigation, and are not to weigh in the scales against him. Before it imposes a sentence of death, the court must be properly satisfied that these two criteria have been fulfilled. End of quote. The Bahamian Court of Appeal had been partially correct in its approach to the first principle to be applied in their lordships' view. And when I say their lordships, the board. The Court of Appeal stated as follows, quote, "The worst cases of murder which may call for the imposition of the death penalty would be those in which the murder is carefully planned and carried out in furtherance of another crime such as armed robbery, rape, drug smuggling, human smuggling, drug wars, gang enforcement policies, kidnapping, preventing witnesses from testifying, serial killers, as well as the killing of innocents for the gratification of base desires." It must be borne in mind that in some of the last mentioned cases, persons who commit murder themselves may be found to be suffering from mental illnesses of one kind or another. And these mental deficiencies may be such that they fall below the level of insanity required by the McNaughton rules. But they are nevertheless sufficiently weighty as to cause justice to be tempered with mercy in their cases. Unfortunately, the Bahamian Court of Appeal then fell into error in that their lordships failed to conclude that there was no basis for believing that the subject murder before them had been planned, not accompanied by any unusual violence beyond that required to effect the killing, nor any evidence of rape, although there was evidence that there had been sex. It was an appalling murder, but not within the category of the most extreme murders. The appeal against sentence was therefore allowed, and the matter remitted for sentencing in the light of the board's judgment. As a postscript, their lordship stated that a sentencing court considering the possible imposition of the death penalty would require to have professional advice as to whether the possibility of reform does not exist. It is clear from the above analysis that the exercise of the judicial discretion treats the value of life with the utmost premium, even in respect of the convicted murderer. The death penalty is reserved for the most extreme cases of murder, and only where there is no prospect of reform of the murderer. It is apposite to note that in addition to the categorization of murder cases that fall to be considered as being within the realm of the extreme, they're just, even if a case falls within the extreme set of categories, the court is not about an arid exercise of just pigeonholing the facts of the matter before them, and therefore coming to the conclusion that because, for instance, it involves a contract killing, it is somehow the worst case, a decision of the board later on. And also there's another recent case involving another contract killing where the Court of Appeal and the board took the view that it was more than just trying to pigeonhole the particular facts before the court into some category, as in it must be extreme because it's a contract killing or it's a drug crime associated with the murder. And these are things that even in Max Otito's instance, when one looks at the error into which the Court of Appeal fell, they were too quick to find that the mere presence of sperm within the deceased led to the conclusion that there had been a rape. And this is what the board was saying. The mere presence of necessarily that there was rape, it means they must have had some sexual relationship, and there may be an explanation. If there is none, it is not proper in a judicial exercise of discretion that presupposes the existence of something that has not been proved, particularly in the criminal justice system. Now, in the circumstances that have confounded our communities, there have been many calls for constitutional change to create a mandatory death penalty, and it is my view that these calls deny the value placed on life and upheld by the rule of law as exercised by our superior courts. It offends, among other things, the proposition that the Bahamas is a constitutional democracy governed by the rule of law. And we who have crawled out of slavery and traveled the centuries-long journey to the freedoms protected by the Constitution and its Bill of Rights should be slow to remove in any way Articles 1 and 2 of the Constitution of the Bahamas, 1973. And in the title, I refer to the case of the state versus Koirati, which is not a murder case, it's really a bail appeal out of Mauritius, where their constitution is very similar to ours. And in that case, the political entities in Mauritius, following their version of Article 54, which is all but identical to ours, set out that It was intended, the legislation abolishing the right to bail was intended to change the constitutional position. It received the requisite majorities in the lower and upper chambers. It then went to a plebiscite and it succeeded. Their lordships in the Privy Council, confronted with that, said, but the one thing you haven't done is to amend your, which are that Mauritius shall be a democratic state. That's our Article 1. The Bahamas shall be a democratic. The Supreme Law Clause. Without getting into the academic argument as to whether the Supreme Law Clause is necessary, the reality is that it exists, and in context, it is fundamental to the upholding of all of the assumed freedoms that we enjoy. And if you take away these provisions, the implication is that you can't rely on them anymore for the other protections that you are seeking to keep. What wording would you use? None of this is confronted in the public. But these are very philosophical questions that ought to be asked and ought to be answered if the public is individually expected to decide whether they vote in a plebiscite to remove any of these provisions. I, for one, am comforted that it is a judicial discretion and not some arbitrary imposition that exists within our criminal legal justice system. I'm comforted by that because the courts represent the institution set aside by the Constitution to provide the guardrails of our democracy, to ensure that majorities, whether super or superficial, are unable to take advantage of those who are in the minority. And you may be in the minority in any number of different ways. We have many people who are poor, who cannot afford legal representation. There are many people who can afford legal representation, but to a point. I'm now involved in a trial that has lasted over a year. There are not many of us who could pay the legal costs associated with that. There are other cases. The Queen versus Vasily, which was in our court system for many years, which went from first instance straight up to the Privy Council, back down to the Court of Appeal, back down to the Supreme Court. And ultimately, because the defendant had the wherewithal to engage counsel throughout the entirety of that ordeal, she succeeded. Is this the type of society that desires to hang in the balance the lives of the poor on the issue of having access to the courts merely on the basis of, or whether by some luck the court has appointed as a freebie, so to speak, a crown brief, and the chap is interested in winning. Now, what's the alternative, you may ask? Because we're being presented with a take it or leave it type proposition. What's being said is because it's discretionary and too many people are not being hanged, let's do away with the discretion. So you ask, well, what's wrong with that? Well, there are many cases, for instance, where self-defense rests on the razor-thin circumstance of whether you believe, as a member of the jury, that reasonable force, and only reasonable force, had been exercised in the confrontation which led to the death of the deceased. If you definitely a shade over the reasonable, in a mandatory death sentence scenario, it doesn't matter. If you look at some of the facts, circumstances of some of the persons who were hanged in recent times, Thomas Walden drugs, his house shot up by his rival, family member injured, and just like all of us, he wanted revenge. And that really is what this choice is aimed at. It is to avenge the death of my family member. But he was hanged. And ironically, the very people who are holding up the life of their deceased loved one are failing to recognize that not only was there value in their loved one, but even in the person of the murderer who took that life. And this is what the discretion that is judicial is aimed at promoting. If it is possible to remove a person from the community who is a danger to everyone, and to set about changing that person in the incarceration process so that he realizes the error of his ways, he attends to changing, ought we not to give that person the chance to change? It is the objectivity brings into the weighing of the scales of justice as opposed to the granting, well, between punishment or mercy. It is not as Caesar standing at the Colosseum with someone crying out and he either thumbs up, yes, or thumbs down, no. It's not as arbitrary as that. And it is the arbitrariness of the mandatory nature of the death penalty in those systems where it is mandatory that calls for criticism. Our legislative approach, following the death penalty cases victories between 2006 and the present day, has been to focus on ensuring that in those cases that the court deems the murder not to actually qualify to be considered the worst of the worst, that nevertheless there are cases where it is so serious that we ought to have a situation in which very heavy sentences are imposed. And my colleague, Mrs. Pindamaki, is going to take you through Section 290 of the Penal Code as amended in 2011. What is clear from the statutory responses is that Parliament has recognized the necessity to properly punish those persons who are not necessarily the worst, but surely not within the realms of being treated as ordinary murderers. And so we have a situation now, and I will be less than 2 minutes, where a life sentence means the natural life of the convicted murderer. Murder sentences will range between 30 and 60 years. So a person who is 28 and who is found to be a real danger, but not yet qualified for the death penalty, may get 60 years. So he, if he is lucky, will live to be 90. That's a real gamble. Our average lifespan is much less than that. And when you take into consideration our genetic predisposition to diabetes, hypertension, and all of that, and the absence of health care in the correctional system that could take you to 70, it is unlikely that a person who is sentenced in the range that is being imposed will ever be seen outside the gates of the correctional facilities. So, if our object is to remove these people from endangering the rest of the community, it's my humble view that we already have in place a system that works in terms of the imposition of long sentences and consistently does so. And for that reason, I ask you to embrace the values of our society, the premium that we place on life and the right to life, and to eschew the temptation to abandon our values and to return to a place of vengeance. Thank you.
Thank you, Mr. Gomez. Really appreciate it. And thank you very much for your quite comprehensive overview of the circumstances of the death penalty as certainly perceived by the Privy Council. May I ask you now, please, to welcome Attorney Reynard Henfield to come and make his presentation. Mr. Henfield.
Thank you so much, Dr. the Honorable Mr. Lloyd. Good evening, everybody. I will begin by pointing out that everyone deserves empathy and a second chance. Everyone deserves empathy and a second chance. But criminals that rape and murder children and senior citizens should receive the death penalty. Criminals that rape, murder children and senior citizens and put the family, the country, and the witnesses through a trial, they should receive the death penalty. Resuming the enforcement of the death penalty in the Bahamas would act as a deterrent to would-be murderers if they knew that the society, our parliament, and our judges were on one accord. If you commit a heinous act, you are in essence signing your death warrant. 20 plus years ago, I moved to the UK to study law. My ambition at that time was to be a criminal defense attorney. My uncle was a criminal defense attorney. I grew up around my uncle, and I had an affinity for criminal defense. I returned to the Bahamas in 2003, and for the first decade of my career, I represented murderers, armed robbers, persons charged with housebreaking, rape, shop breaking, gun possession, drug trafficking. 10 years after doing those types of cases, at one point I would say I was blessed that I had never lost one. But 10 years afterwards, I transitioned from being a criminal defense attorney and I moved more into activism, family law, and then the dreaded parliament. My perspective obviously comes from somebody who aspired to defend persons accused of crime, to become someone advocating and agitating to protect our citizenry. So what changed? I've heard the argument by many opponents around the world of the death penalty that the death penalty doesn't deter crime. And if you go online, it actually is phrased that there is no convincing proof that the death penalty deters crime. Not that there's no evidence that the death penalty prevents crime or deters crime, but it's phrased, there's no convincing evidence by the writer. So the writer of that statement is not convinced. My personal experience in coming up under my uncle, studying law, practicing law, is that persons accused of murder are terrified of being caught and being killed. Terrified. If there's one thing that criminals are afraid of in this country, with the greatest respect to the police in the room, it's not the police. It's that if the law of the land were to play out, not the police. There's no fear of the police. The fear is that the law of the land may be carried out if they're caught. I have watched as petty thieves become hardened criminals, as persons escalated from disorderly behavior to grievous bodily harm, or assault with a deadly weapon to multiple murders. As a criminal attorney, though, I had a duty to provide my client the best defense possible. As I walked away and moved into activism and then Parliament, I had realized that as a member of this society, as a community leader, national leader, or legislator, we have a responsibility to protect our citizenry, especially the most vulnerable, our children, our senior citizens, our women and girls. And that's from those who violently traumatize and end their lives, like in the manners we've seen in the last few weeks in this country. As a society and as a government, we respect life and law-abiding citizens' right to life and peace of mind. Our people ought not live in fear of criminals and crime. Criminals ought to live in fear of our laws. Some criminals, especially in the last decade, have demonstrated utter disregard for human life, law and order. And their continued presence in our society further emboldens other criminals, thus further endangering hundreds of our citizens every year. There appears to be no fear of the law and an assurance that they'll be out on bail in a matter of months, if only to continue their rampage or to silence the witnesses in their cases. In a country of around 400,000 people, our people have been traumatized and terrorized by murderers in this generation to gun down citizens in broad daylight, to kidnap, rape, and murder children, to break into the homes of our grandparents, rape and murder them. There was a point in time in this country where you heard of a murder after and traumatized. Now our children, our parents are witnessing murders far too often. Not hearing about it that it happened 2, 3, 4 o'clock in the morning, but witnessing children who are traumatized for life. For the past decade, our people have endured on average 100 murders per year. And if you would actually do the math, you would find out in the last decade, over 1,100 of our people in our small society have been murdered. That's more than 1,100 families, parents, children, siblings, cousins, traumatized. Many in our society are of the view that the worst of the worst offenses include the rape and murder of a child or a senior citizen, the commission of multiple murders, the murder of a juror, a judge, a police officer in the course of their duties, and a government official. Human trafficking that results in multiple deaths, drug trafficking involving murder, terrorism, armed robbery with murder, home invasion with a murder. When we are asked by persons and bodies outside of the Bahamas to abolish the death penalty, what it translates to many of us is there are people who don't endure the trauma that we endure in our country, in our community, in our families, telling us that the loss of our loved ones isn't that serious. Move on. That we don't deserve justice. Yet when a pit bull kills a child, we put that animal down. Many believe the same should be done for these heinous murderers. When a grown man can kidnap, rape, and strangle a child, to us, that's the worst of the worst. That's worse than a pit bull killing a child. The death penalty affords the murdered victim and their traumatized family, and by extension, our traumatized small society, a sense of justice. Murderers are now a public menace and have clearly become influencers of other young men in our small society. They are now role models and social media influencers as they cut their movies, they say, captured on cell phones, and the bodies of their victims and the grieving family members are plastered all over social media. A few years ago, I met a teenager doing some work at my property with his father, 17 years old. In speaking with the young man, I said, "You going to take the father's business over?" He says, "Not me." I said, "But Daddy done got these big trucks, tractors. I was hoping to get a discount. Daddy was charging $4,000 for land clearing. You have a ready-made business to move into?" He says, "No. He wants to be like a gentleman in his community. That's his role model. I suspect that I'm going to hire a drug dealer." The 17-year-old boy says the role model, the person he wants to be like, is a young man in his community has already murdered 12 people. At $3,000 a head. That's what a life is worth to a hitman in this country. Or someone's taken as a favor for their boy. But this is his role model. So murderers have emboldened our young men in this country. It's a sign of something to aspire to. Because the law that's on the books isn't being carried out. So it's something to aspire to. When persons and bodies that don't endure our trauma ask that we abolish the death penalty and give all murderers life imprisonment instead, what they are saying is, you locals should care for that heinous murderer at a cost of $17,369.60 per year at the prison. It's $17,369.60 to be exact. And that's what they want you to do. Care for them for life at a cost to us as taxpayers of $17,369.60 per year. While they're in prison, they'll enjoy frequent visits from their family and friends, home-cooked meals, freshly laundered clothes, and bedding. While the murdered victims' families are left to cry themselves to sleep, go through depression, visit a grave with flowers. Not to forget that the person who is then remanded or sentenced to prison for life enjoys access to a cell phone, the occasional marijuana joint, that's following the news just as you are on your phones. For the record, the Bahamas has never imposed the death penalty on a minor, a child, a woman, or a person with a mental disability. And persons is not something we do in the Bahamas. When we have a national conversation on a national issue such as this, one would think that the only voices that are relevant are those of the nationals plagued with the crisis, the terror, and the trauma of heinous crimes. But quite to the contrary, national discussions such as this have always garnered international input, with countries and persons from around the world who don't endure what we endure in this country, telling us, you didn't do what we did. You live in a country with millions of people, where you have 60 to 70 murders a year. We live in a small community of 400,000 people, where we're enduring 100 plus murders per year. Something has to be done. But let's not lay the blame at the foreign entities or persons. Truth is, our policy makers are not prepared to do everything possible to ensure the safety of our minor children, our grandparents, our women and girls, and our young men. Yet on the other hand, are quick to rise in Parliament and pass laws to conform to the dictates and demands of how our people, our communities, and our country should operate. Many Bahamians demand capital punishment for serious crimes, and many, like myself, agitate more specifically for capital punishment for the most egregious crimes, the worst of the worst, for a safer environment for our children, our grandparents, our women, our girls, and our now near endangered populace, our young men. So, moratorium. When last have you heard of someone sentenced to death in this country? The last person executed in this country was in 2000, January 6, 24 years yesterday, who was then represented by the now Prime Minister. The last time someone was sentenced to death, I think the prosecutor who is now Justice Neil Brathwaite, and that sentence was commuted by our now President of the Court of Appeal. The opponents of the death penalty tell us that you are being barbaric. If someone rapes and murders your child, breaks into your parents' house, rape and kill them, that you are barbaric. That monster was barbaric. And the law of the land is a reflection of us as a society. As a society, this society predominantly supports the death penalty for the worst of the worst. I thank you.
Mr. Henfield, thank you so very much. Appreciate it. Again, please forgive me, Professor, but may I kindly ask you to welcome Professor Carsten Zackler from the Bar of Ireland.
Thank you very much. Ladies and gentlemen, I am here to offer an outsider's perspective. And I'm very conscious of the fact that capital punishment matter and a deeply personal matter. It is really one of those questions that every individual personally has to settle for themselves, what their position is on it. It is something that every nation, every society has to settle for itself, whether it is right or not, whether it fits in with its traditions or not. And it's something that is for every jurisdiction to settle individually. I'm in no position to lecture you on what the position ought to be on the death penalty. And I think you may also think that it is of rather limited value for your decisions here what my personal views are. So I have really come with remarks, 3 sets of remarks which I would like to offer to you. Firstly, briefly, a glimpse of the outside world, to the extent that it may sometimes be useful to have a look at what other countries, what other jurisdictions have done who've had to tackle the same sort of issues. Secondly, I would like to offer some deeply personal thoughts as regards how I approach the issue of capital punishment. And finally, I would like to offer some comments of a procedural nature, really. Let me start with a glimpse of the outside world. I think there it is relatively clear that the trend worldwide has been in the direction of abolition of capital punishment, or at least the imposition of a moratorium on capital punishment. When I was born, which is somewhat more than 50 years ago, but not that much more, I'm relatively young still on that front, quite a lot of European countries still had capital punishment on their statute books, though most of them had not applied it, even then, for decades. Nowadays, if my information is correct, there's only one European country, Belarus, which still has capital punishment. Everybody else, including Russia, has abolished it, and indeed that's a condition for accession to the European Convention on Human Rights. It's a condition for accession to the European Union. If you look at the OECD countries, the 30 OECD countries, a club of supposedly the most wealthy and most well-developed liberal democracies, it's only 2 out of those 30 that still have capital punishment. Though you may note they're rather important members of that club. The United States and Japan still have capital punishment on the statute books. There's been a general trend at the level of the United Nations for the General Assembly to have repetitive motions imposing, or rather calling for a moratorium on executions, a moratorium on the application of capital punishment. There have been 10 such resolutions in the last years, and the most recent one was carried by 130 members of the General Assembly of the United Nations, subscribing to and calling for a moratorium on capital punishment. And I'm not sure whether this is widely known here, but the last resolution that was passed, which was I think in November last year, 2024, was the first time that the Bahamas government did not oppose that resolution. Bahamas abstained on the resolution calling for moratorium on capital punishment for the first time. Now, I think this general global trend, which is a trend that, as I've said, is particularly strong in Europe, I think there's no doubt that it informed the decision of the Privy Council and Max Otido. It is quite clear, to me at least, reading that judgment, that the board, their lordships, tried to make it difficult for capital punishment to actually be applied, because that is clearly something that was informed by the traditions that are prevalent in Europe, and which of course the members of the board are part of and can't really shield themselves from. Now that's the general trend worldwide, but I have to say personally I'm not a fan of bandwagons, and I think just because somebody else is doing something is not a reason that you ought to be doing it. I think it's important to look not at what is being done, but why it's being done, and ask yourselves whether those reasons apply to you as well, or whether they apply with nuances. And Mr. Henfield helpfully pointed to some of the differences in this jurisdiction as regards that. So that's entirely comprehensible. Now I, myself, I'm a public lawyer, I'm a constitutional lawyer, I'm a human rights lawyer. I also practice corporate and investment law. And as I said, capital punishment really got abolished in the European Union countries where I practice when I was actually very young. So it is not something that I have had to deal with as a human rights lawyer in my practice ever, because it is so universally accepted inside the European Union that there is no capital punishment that's being imposed. So I think you'll find it entirely unsurprising for me to say that personally I'm resolutely opposed to capital punishment, and that is just the culture in which I grew up, in which I was educated as a lawyer. I have to recognize that. So I took this talk here this evening as an opportunity for reflecting. What are the reasons that lead me very personally, I hasten to emphasize, of course, that this is a personal view which you don't need to share or espouse, but what leads me to come to that conclusion that for me, capital punishment is not acceptable. And I'll just give you a little glimpse, particularly in a church hall. I'm not going to invoke spiritual issues, religious issues. I think there are others who are better placed to talk about that. But for me, I think it may be a variation on one theme. I have three remarks. The first remark is it's important to think, when you're approaching these moral issues, to think about your own personal moral compass and to take your own views as a starting point. And I say that because very often people thinking about capital punishment fall into the trap of trying to judge criminals by the standards of the criminals and say that, well, this individual themselves killed, therefore let's kill them. This individual did not respect life, therefore we do not need to respect their life. That, to my mind, is not a proper way of reasoning. To my mind, one has to start with one's own moral compass, and not, in a way, leave the moral high ground and go down to the moral compass, to the standards of the criminals. I'm not suggesting anybody is doing that or advocating for it, but it's an easy trap to fall into. The eye for an eye, tooth for tooth, sort of way of thinking. The second thought I'd like to offer is that as legislators, as lawyers, I think most of those present here are probably lawyers or have some contact with legal professions. When you lead, I believe one should lead by example. And if you conclude for yourself that killing is wrong, you would not kill, then I would respectfully submit that it is only coherent not to sanction state killing either. Because if you wouldn't do it yourself, why authorize somebody else to do it? And this leads me to my third, as I say, very personal comment, that it may be useful to have really a red line, a bright line, to declare that this is a line we will not cross, we will not kill, we will not have state-sanctioned killing, in particular in times, globally, where dictatorships are on the rise again. And again, I need to say, I'm not offering this as advice to you. I'm not saying that this is a risk in your jurisdiction. I'm just observing really on the outside trends. Because it is, of course, in particular dictatorships which then abuse capital punishment, abuse the death penalty, and in particular when it can be applied for matters such as treason. I think it is worrying, and it's easily abused. And if you look at the list of countries that apply capital punishment and put most people to death on a year-to-year basis, it's not a club I would submit that you'd like to join. Now, having said that, let me get to my final point, the procedural thoughts, which I'd like to impress on you. Procedural thoughts about coming to conclusions regarding capital punishment. I think it's, to state the obvious, nobody says anything else, capital punishment, the death penalty, is a very serious matter, maybe the most serious matter that any lawyer has to ever consider or argue for. And decisions about it must be well considered. And there should be robust safeguards in place that decisions regarding capital punishment are properly taken and properly considered. As regards the decisions being well considered, I think of two dimensions in particular. First of all, the general question that may be put to a population in a referendum, popular vote or even the vote in Parliament, needs to be well considered. It needs to be not a knee-jerk reaction to recent events, recent trends. It has to be carefully considered, and ideally there ought to be procedural safeguards to ensure that it does not fall foul of or fall victim to some social media campaign, some populist campaign in one direction or another. How does one safeguard against that? I think one safeguards against it by having meetings such as this to inform the population, to discuss this matter, and to discuss it openly and in depth, and not rush decisions on it. So time is often an important procedural safeguard. That's the first dimension. So in coming to any general conclusion as to whether to apply capital punishment in more cases, whether to abolish it, it needs to be well considered in general. But also at the individual, I would say it is equally important, maybe even more important, that when in an individual case, an individual judge is in a position where they have to apply or consider applying capital punishment, it is extremely important that that individual ought to be guard it from external pressures. And that is something that I would say is difficult of the victim and the family of the perpetrator. And I think that is something where it's a question where one needs to think about what sort of procedural safeguards one can put in place so that the individual judges who would ever be called upon making this decision themselves can do so in good conscience and do not fall prone to populist attacks effectively. The second and final procedural safeguard that I would like to talk about is safeguards themselves. I would strongly say that nothing in the law, in the application of the law, should ever be made mandatory. We have judges for a very good reason, because they exercise judgment. The name gives it away. The title gives it away. And every case is different from everyone. So it is extremely difficult to have foregone conclusions, to have a recipe set out in a statute book, saying if these conditions are met, then capital punishment has to be applied, irrespective of what the judge says. Self-defense was the example given by Mr. Gomez, with all of whose arguments I very respectfully agree, and which I would adopt in that respect. Self-defense is an extremely good example where it is also perfectly clear that there's going to be very little deterrent effect of imposing capital punishment in cases where there's no element of premeditation. Because if you, in a way, in the spur of the moment, without having thought about it in advance, are involved in a situation which leads to the death of an individual, precisely because you won't have had an opportunity of thinking about it, I would say it's relatively unclear that there is any deterrent effect by ramping up the sentence and putting a death sentence onto the statute book. And in many ways, Maxo Tido, where premeditation was not shown, is in a way quite a bad example, quite a bad precedent to try and rely on in order to say that capital punishment ought to be reintroduced. Those are my thoughts. That's what I wanted to say. I should add, maybe, and I've been given the liberty of adding a very short pitch at the end of my remarks, that I'm not in this beautiful country just in order to present these remarks. I'm actually here as a part of the wider CARICOM and Council of Legal Education Law School project to review the curriculum of legal education in the Caribbean as a whole. And my little pitch to you is, if any of you, this shouldn't include any of the questions that we're going to have in a moment, but if any of you have got a particular strong view about the curriculum of legal education in the Bahamas, please do buttonhole me after this event is over. Thank you very much.
Professor, you took my paper, but never mind. Please let us... No, none at all. Ladies and gentlemen, please, for our final speaker this evening, Mrs. Taipinder Maki, kindly welcome her.
Good evening, everyone. Firstly, I would like to say that I fully echo what Mr. Gomez Casey had to say relative to the dangers of making the death penalty mandatory and removing the judge's discretion. I am here to speak to you from a defense counsel perspective. A sentence such as the death penalty is simply not desirable. It can simply not be a one-size-fits-all. Considerations, in my opinion, there are many factors that need to be considered. The charge itself. How did the office of the DPP arrive at the decision to charge? The recommendations from the Royal Bahamas Police Force, the investigation of the matter itself, and the thoroughness of that investigation. Was the defendant, at the time of arrest, represented? Did he have the means to be represented at the station and or at trial? And further, what was the quality of that representation? I am not attempting to cast aspersions on anyone. However, the reality is that there is potential for a considerable margin of error in this regard. And in my 16 years of practice, I have found that these are real issues. So we must be careful in making a death sentence mandatory. As stated in the case of Maxo Tito, which Mr. Gomez would have touched on earlier, murder is always a heinous crime. But the death sentence is the ultimate and final sentence, and it must be reserved for the wholly exceptional category of cases within this most serious class of offense. And this is codified in our Penal Code, Amended Act 2011, which sets out the circumstances as to what is the worst of the worst. At section 290, subsection 2, subsection A. And these circumstances are the murder of a member of a disciplined force acting in execution of his duties or of a person assisting a member so acting. Also, a judicial officer acting in the execution of his duties or of a person assisting a judicial officer so acting. Or any person acting pursuant to powers, authorities, and privileges as are given to members of the Royal Bahamas Police Force under the provisions of any law in force for the time being. B, the murder of any person for any reason attributable to 1, the status of that person as a witness or party in a pending or concluded civil cause or matter or in any criminal proceedings, or 2, the service or past service of that person as a juror in any criminal trial. C, any murder committed by a person in the cause of a furtherance of 1, robbery, 2, rape, 3, kidnapping, 4, terrorism, and any other felony. D, the murder of more than one person. E, any murder committed by a person who before that murder had been previously convicted of another murder done on a different occasion anywhere within or outside of the Bahamas. F, any murder committed pursuant to an arrangement whereby money or anything of value, 1, passes or is intended to pass from one person to another or to a third party at the request or direction of that other person, or 2, is promised by one person to another or to a third person at the request or direction of that other person, as consideration for that other person causing or assisting in causing the death of any person, or counseling or procuring any person to do any act causing or assisting in causing that death. And even if one of these circumstances do exist, there must be no possibility of reform. Well, based on what we would have heard from my learned friend, Mr. Henfield, and based on some of the comments I would have heard during his very passionate speech, concerned citizens of the Bahamas appear to hold the belief that if we bring back the mandatory death sentence, this will act as a deterrent and a decrease in the murder rate. However, the statistics simply do not demonstrate that. Over the years, it is abundantly clear that the murder rate fluctuates from year to year. In the year 2000, we have the hanging of David Mitchell. That would have been the last exercise of the death penalty in the Bahamas. David Mitchell was hung on the 6th of January, the beginning of the year. The mandatory death sentence had not yet been abolished. And however, in that same year of 2000, there was a significant increase in the murder rate of 53.52% from the previous year. And the mandatory death penalty was still in place. Similarly, after the mandatory death penalty was removed in 2006, there was a decrease in the murder rate in 2008, 2012, 2016. And so it is obvious that some years you have an uptick, and others there is a downward trend. And so it is my humble opinion that focus ought not to be on the death penalty, but the focus ought to be on the prevention of dangerous crimes. How do we protect ourselves from the importation of illegal firearms and the trafficking of contraband? How do we move towards developing real intelligence gathering capacity rather than a mandatory death penalty? Again, I will reiterate, these are my personal views, and I too believe that life is sacred. I do believe that the preservation of life is paramount, and an eye for an eye simply will not solve the problem, nor will it hinder crime. And that is my personal view.
It's my personal view that you all have done an excellent job tonight. Let's give them a round of applause, please. Now, as announced earlier, ladies and gentlemen, we invite you please to join in our participation. There are two microphones. You can easily present yourself at either, if you wish, and we would like to encourage you to state your name. I'm Jeffrey Lloyd, and this question goes to Mr. Gomez. If I may, with your permission, I'd like to ask two questions, please, of our panel. So, Mrs. Pinder Mackey, what do you say to those Bahamians who, like Mr. Henfield states, feel aggrieved that this heinous murderer enjoys the comfort of the comfort of the all-inclusive enforcing at a cost of $17,000 plus per annum, while your grieving family suffers depression and is in fact required to share in that expense year in and year out. What saith you? And may you kindly use the microphone that is on the table, and I think the organizer is prepared.
Well, I would say that firstly, if you have ever visited that establishment, you would know that that is no sweeter Bahama. And so therefore, I do not feel as though the death penalty is still warranted. What I find Bahamian citizens tend to do is they seem to be quite bloodthirsty at times, and it is not until it knocks at their door and it's now their good son or their good cousin that they now realize that the preservation of life is important. And so whilst you may be aggrieved, the reality is there's still that margin of error. And that is my response to that.
And Mr. Henfield, picking up from Ms. Pindermaki and Mr. Gomez, there have been instances, I am advised, where an innocent person in this country have been hung. How would you sleep at night knowing that there is a real possibility that an innocent person due to the circumstances described by Mr. Gomez and Mrs. Pindamaki, may in fact suffer that irreversible penalty called the death penalty.
Thank you so much, Mr. Lloyd. Throughout the world, various countries, you have many persons who are opponents, remind us of the fact that our criminal justice system is flawed. Right at home, we have that. As attorneys, we all know that. We may not like to say it, but we know that. When those of us, or persons like myself, who agitate for the death penalty, for the worst of the worst, who have gone through a whole trial, have been found guilty by a jury of their peers, and sentenced pursuant to the law by a judge, I am comfortable with that. I am comfortable with that, Mr. Lloyd. If they are found guilty by a jury of their peers, they've exhausted their appeals, their conviction has been confirmed, I would sleep well, Mr. Lloyd.
Thank you very much. Those are my two questions. There might be more later. Thank you, sir. Please.
Good evening, all. Keith Seymour, partner at Aspinall Chambers, criminal defense attorney. I have a question for Jeff. I'm going to break your protocol for both Leonard Casey and the Leonard Professor. It appears as if the charges that are laid with the murder charges don't reflect that at the end of the day that there is the death penalty for that. It only is the actual 30 to 60 year sentence. Who's responsible for that in your view?
Under the legislation, the DPP is responsible at the beginning of the process.
Yes.
To indicate whether the death penalty is being pursued. And that has ramifications on the jury side. Also, it's not without criticism. In the Ernest Lockhart case, defense counsel criticized the fact that there was no written communication giving any details as to why it was being sought. While that is a valid moral argument, the legislation itself did not require any formality in how the information is being expressed that the death penalty is being pursued.
So, for the Leonard Professor, do you think that is fair in the circumstances as the Leonard Casey indicated to the public who are not
saying it's fair? I said it may be morally reprehensible, but the statute did not require any formality, so that was the out that the DPP had in the appeal.
Understood, Mr. Gomez. I used the wrong word, fair, but my Leonard friend, Ms. Pindamaki, indicated there are instances where people may be thirsty, bloodthirsty. Is that a situation where the public could be satisfied with that type of result if there's a preliminary judgment by the DPP to say, well, we don't want the death penalty in this instance? I'd like to hear your response to that, please.
I have to say, for myself, as regards the specific procedures here, and of course cases in this jurisdiction, it's of very limited value, the extent to which I can comment. What I would take from this, however, as a matter of general principle of natural justice almost, is the question of the foreseeability of punishments, the foreseeability of sentencing. I think from that point of view, it is, first of all, of course, important that the statutes be clear as regards the circumstances in which the death penalty may be sought. And particularly because the death penalty is such a severe sentence. So as long as it remains on the statute books, I would say that it is probably proper in order to concentrate people's minds when they go through the legal process, that there should be an announcement at the beginning whether that sentence is going to be sought. Because it makes everything more serious that follows. That's the reasoning for the
Thank you, gentlemen.
Yes, sir. Thank you.
Good evening to the panel. My name is David Cash. I have a question for Ms. Mackey. Ms. Mackey, as someone who ordinarily practices in the criminal justice system, do you feel that our system is capable in terms of providing the Bahamian people the point where they can be satisfied that once someone is convicted, that they are actually guilty? And my example is we still have a vast number of cases that are determined only based on confessions taken in circumstances where individuals surrender themselves to custody or are arrested and give these confessions without counsel. There is no mandatory system in place. There is a system in place for persons to be represented by counsel at the Supreme Court at trial, but not in the police station. And so they can be held for as much as 5 days. The majority of their detention is only given by detention record. They're not on video during the 70 hours of their custody. Only the 2 hours they're on video confessing. And so the majority of their custody cannot be accounted for, whether there's any brutality, whether there's any inducement, any of those things. And then you have these convictions that are solely based on these confessions, where the entirety of their custody cannot be accounted for. And I'm often faced with the question of, what if you have a situation where you know the person is guilty, or they are this level of guilty, 100% so, but the courts do not categorize persons as, oh, this person was convicted 6-3, or this person was convicted unanimously, or whatever, because we've taken murder, well, certainly not capital murder. Capital murder still things requires all of the jurors. But do you think that we have a system that can guarantee actual guilt? And if we cannot guarantee actual guilt, should we be enforcing the ultimate penalty?
This is what I was referring to when I was speaking about the margin of error and the investigation itself. So at the investigative stage, as you would have rightly pointed out, a lot of times once this matter comes before the court, you simply have only a confession. You don't have any type of material evidence whatsoever. You don't have any eyewitness evidence. And there's most times, in my experience, where there's simply a confession evidence, there's really no corroboration there. And so I think that it's very dangerous to now impose a mandatory death penalty, just as you would have indicated, where you just have a confession, especially if there was no counsel accompanying that defendant at the time of this confession, which we would know in this jurisdiction happens frequently if you're practicing criminal defense law. You know that this is something that is a real issue, a real life issue, and so the mandatory death sentence cannot be considered to be desirable in this particular state.
Thank you. Thank you, Dr.
If I might also add, the state of the use of forensic evidence is less than optimal. And we have used scientific facilities in Florida in the preparation of the scientific part of proving the case. When we are doing well and we have paid whatever is due to the lab, we get the results. Now, it is too often that those results are not readily available during the early stages of the criminal proceedings. It impacts the defendants because the sooner you get counter opinions from alternative experts, the more likely you are to be able to mount a credible defense. In the midst of this reality, we now have a change to the criminal procedure rules, which requires the defendant to give a statement of what his defense is going to be. And one of the criticisms that I have of that is that if I don't know what your case is, and I am unable to get scientific evidence to counter it, what is the point in you guessing, well, not guessing, being told what my defense is intended to be? And the presumptions are raised by your failure to cooperate in giving the statement. It's a serious issue. And in murder, sadly, in most cases, the scientific evidence is very, very important.
Thank you. Yes, sir.
Good evening, good evening. My name is Benjamin Dames. I'm a minister of Jesus Christ. I'm a biblical spiritual psychologist, understanding the human soul. Let me ask all of you all a question. Do you believe in God? How many of you? Thank you. Do you believe that God is the supreme judge? Do you believe that God set up authority in the earth and not man? Now, all of us sits in some sort of position of authority. I know most of you all. Now, you're looking at an individual who have the highest degree ever bestowed upon a human being. The highest degree. You know what it is? Common sense. Came from God. See, you can be very educated, but if you don't apply common sense, you can never speak intelligently. There's a difference between murder and killing, but the result is the same, where a life is taken. Murder is defined in our law is willfully, intentionally, and lawfully taking the life of another. Now, I have all rights to kill. All of us here have the rights to kill. When someone tries to murder you, if someone tried to murder you, Mr. Gomez, Mr. Hanfield, you have the God-given rights, the self-defense rights, the Constitution rights to protect your life, to kill. The Bible says in Ecclesiastes 3, there's a time, purpose, and season for everything under heaven. That means on earth. Let me finish.
Before you continue,
Okay, let me finish.
there is no right to kill.
Let me
There's
finish.
a right to use reasonable force.
No, that's not
Up
true.
to, I'm telling you.
No.
Up to
Mr. Gomez, now I can educate you, I can inform you, or I can educate you, and I want to educate you. Let me say this to you. I believe, and listen to me, every law that y'all was taught, it came from the Bible. Now let me say this to you. When we talk about murder, the Bible says there is a time to kill. Ecclesiastes chapter 3. Time to kill. And you have killed before. All of y'all have killed. Probably you never killed nothing before? You sure? Mosquito? Have you killed? Yes or no? Yes or no? Have you ever murdered a mosquito? Okay, let me say this. Mr. Hanfield, I applaud you with applying the greatest degree ever bestowed upon a human being, common sense. But let me say this. You're looking at someone, you see Tito Kadogo? That's my cousin who was killed. You're looking at someone who pushed up about 11 persons at Foxhill Prison. I was there when they got hanged. 3 at one morning, 3 from Cat Island. I was not a new creation in Christ yet, but it didn't bother me because why? It was justice was carried out. You see, close to this. You said something, Mr. Hanfield. Everybody has an opinion. I respect people's opinion. But when truth shows up with opinion, opinion has no place. It must die. And so I say this. What you have said, the government is the failure. It's the government that God has set up in the earth to execute the soul. Romans chapter 13, 1 through 4. The government is the avengers. You know why we have revenge killing? It's because the government failed to become the avenger. The Bible says, he said, they are his ministers. Do you know the prime minister and the police officer commission? They are ministers of God. Read the book. Romans chapter 13, 1 through 4. He said, and he gave them a sword to execute the sword on them that do evil. But when, imagine this, when the government, who was given the sword to execute the sword on them that do evil, and they themselves doing evil, who's going to execute the sword on them? Only God. Because of the failure of those persons who are sitting in the seat of authority, it failed the people. The Bible states human law came into existence in Genesis 9:6. The Bible says Jesus after the flood. He said, the point is this. We in this country where we live, and I employ again Mr. Hanfield, when a death sentence was carried in this country with Poker, Red, 3 guys from Cat Island, Schubeck. Listen, it's like a spirit was moved from over this country. Quiet, because why? Justice was done.
May I kindly ask you, sir, if you have a question?
Okay, that's my comment. Good. You
No, do you have a question?
Yeah, I've got a question.
We need you to get to the question because
Okay.
I'm sure they have others who...
I'm fine.
No, I don't need you to get to the
I
question.
get the question.
No, not to get to. Get to the question.
Okay, I will get to the question.
Please get it to him, and that's so that we can have others to participate.
Okay. The question for all of you, and for him too, is this. Why should not the government, who was given the sword of authority to execute it on the persons who commit murder, takes another person's life, why they should not be receive the death capital punishment for a capital offense. Anyone y'all can answer that. Why the government should not carry out the death penalty on those persons who willfully, intentionally, and lawfully takes the life of another.
Mr. Gomez, would you, Professor? Mr. Ndamaki? I see. Question, sir?
Good night to you all. My name is Garth Rhodesborough. I'm the host of Remark, and I sit with our grant of the Children's Foundation, establishing Miller on Beyond the Headlines as a contributor. I'm looking at the consistency of the law, not a legal mind. Therefore, I stand humble before you tonight. My issue is simple, that I do believe it was mentioned that the last hanging was somewhere around the year 2000. And we're now presently in the year 2025. I do understand that even a learned friend has said theologically that there is something in the Bible called the death penalty. But I also understand that there was also grace and mercy. Cain kills Abel, but God doesn't kill Cain. One of the most painful incidents I know about in the Bible is when Uzzah touched the ark. And as a child I cried because just to save the ark, why did he have to die? Why I'm standing here is because if laws do exist, if they stand before all men, all women, all children, the law, to be obeyed, I'm seeing the consistent grace and mercy and forgiveness to the point now where we can surely recognize that the generation of murderers have no fear of the law. If it were where every now and then, maybe every 2 years, 7 years, every 7 months, every 5 months, whatever, but I don't have the surety of actually committing this murder that I may be spared or I may die. Just the very notion of that says to me that the law is alive and well, and the judicial system has the freedom to execute according either to whether they believe in God or they believe in the psyche of the mind or the strength of legislation. I am simply asking and saying to you, I understand the word opinion, I understand the word fact. If it is your opinion, as I have been a minister of the gospel in the past, where I've been soft, where I said you shouldn't kill anybody who's a murderer, let them live. I am now at a point where I'm saying anyone who commits a heinous crime, not once, not twice, but 3 times, you still haven't killed them yet. You have still not put them before the nukes or give them a lethal injection as yet. This is a person who is a detriment and is a danger to society as we know it, and will continue exponentially to share that spirit of evil to the entire nation. So we've gone in the year 2000 to how many murders? And now how many murders do we now boast of in 2024? 2024 was a year where the bloodbath was 120 plus individuals that had no fear whatsoever of a consequence. All I'm simply asking is that even though it's your opinion, even though it's your faith, even though you sleep well at night knowing that no murderer will go before the death penalty, I'm asking you once again to put aside your own opinion, put aside your own emotion and look to the law and why that law exists. And if that law exists honorably, let us allow ourselves as a nation to exercise that law, whether we admit the death penalty or we give grace and mercy, but let it be known solely with the judicial system, whether you live or die as a murderer. We have to have that strength in this nation.
Do we have a responder? No, sir? Question, sir?
Good evening. Wayne Clare, Catechist, St. Stephen's Powers, Andrews. Now, before I ask the question, I have.
We temper justice with mercy.
Thank you, sir. And first I must say, I I'm not a legal-minded person, and I heard the presentation tonight. Some went over my head. I was hoping that they speak more on the layman's time instead of the legal time, so that all ancillaries probably would digest and hear with understanding. Having said that, I can recall in the early 70s, in Feshwick Andrews, where there was a murder committed in that community. That whole island was numb, like someone close to them had died. Fast forward to today, 2-3 murders a day. It's a normal thing. We don't say murder number, we say murder number 1, murder number 2. We even don't call the victim name no more. We as a nation must come together and see what it is. We have lost our moral compass when it comes to murder. Now, you may take this as a punch to the legal minded, but we have too much legal lawyers in House of Assembly making laws so that there are loopholes, and they say, okay, I heard that my friend here, I don't know his name, but I heard him say, this one do away with capital punishment, that do away with capital punishment. So, know what comes to mind when I said it now? Same-sex marriage. Canada do away with biblical ruling on it. America don't have that, so the Bahamas must accept it too. We must stand and stand alone. If it's wrong, it is wrong. With me? So then, if the courts say he's guilty, carry it out. Carry it out. We need to take it out. So what I'm saying is this. What the lawyers are saying now is that. Question I want to know is to Brother Gomez and Madonna Frederick. What does it take for us to move away from the Privy Council, put in place legal framework where we can say, the Court of Appeal Bahamas is the final decision making. What needs to be done? That's question number one. What needs to be taken place? Does a referendum need to come in the force where each behemoth who voted had to say yes or no? What process, what legal action need to be taken for that step one to be taken place? That's what I can answer. Number one. Can I answer that question?
At present, my position says that the Court of Appeal is the final Court of Appeal in criminal matters. However, where a person wishes to petition the Queen,
the King
can go, or by the King, sorry.
Yeah.
I grew up mostly under the last one. You go by way of special leave to the Privy Council. And that is the process by which the Privy Council is engaged. You may have people who vote for that. You may find that a majority of people don't agree with you. And they may be persons who rely on the Privy Council for commercial matters. The weakening of the judicial system has wider ramifications than just for criminals. Criminal law is actually a very small fraction of what we do in practice. And the public isn't aware of that. But most lawyers, in fact, the criminal law is one of the smallest fractions of the bar. If we have more than 15 people who are regularly before the criminal courts, we've got many. So you've got to be very careful about making decisions that could lead to massive unemployment if sectors decide to leave and go somewhere else. And that has happened in certain instances. We lost a lot of insurance business in the 70s to Bermuda. We changed our laws and they never came back. And they're still in Bermuda. We've had changes in our laws and offshore banks have left in droves. So when you sit down and decide, I am going to do something that is serious, and altering the courts is a very serious matter. Taking away judicial discretion is an extremely serious matter. It sends a signal to your business partners who may not even be behaving. People stop doing business with you. You see hotels starting to close down. Investment starts to dry up. It's more difficult to get employment. You know, life is not as simple as it used to be. In fact, you know, as a boy, I knew when there were farmers who were working. I listened today about the cost of doing business. I don't know how a farmer can afford to pay for water and electricity if that is what he needs to sow his crops. But decisions that are made need to be made after we have thought through what we are doing. I have painfully taken you through the decisions of our courts, not politicians, in order to show you that it is not a simple matter of a politician making a decision. The politics had nothing to do with what the Privy Council decided in Max Tito. The response that the government gave was not a politically popular position to take. It was measured. It was careful. It was intended to show the public that we do not trifle with major institutions in our country. And the third arm of government is that very court system. So we are very careful to make sure that when we speak about these things, we are not whipping up hysteria, but tampering down the conversation so that people can confidently understand what is going on. That's the first thing. Understand what the issues are. The second thing is then, where do I stand on the issues? The third thing is, what am I going to do? And it may be easier for some than it is for others. But the decision has to be one that comes from information. If you don't understand what I said, and there's something that you wish for me to explain, I'm happy to explain it.
What?
If I can, but I'm just saying to you that the whole point of this exercise was not to promote or denigrate any particular position, but to give the arguments for and against, so that you, the public, can make a decision. What you do is completely up to you.
Okay, but Gomez, one question, then I can sit down. Did Barbados move away from the Privy Council?
They have gone to the CCJ, but the CCJ has
CCJ is
the Caribbean Court of Justice, which sits in Trinidad.
Right.
They have decided that they are bound in jurisdictions that were subject to Privy Council rulings. When they come to those jurisdictions, they are to apply the law as it is. They have not sought to deviate in any way from the reasoning given by Privy Council rulings across the region. And the Privy Council itself has approached each of the Caribbean jurisdictions, as well as those that we don't traditionally regard as being West Indian, like Bermuda, Cayman, and Turks and Caicos. They've treated them as part of the Caribbean judicial community. So they said in Tito, Caribbean courts. They actually start out the ruling by commending Caribbean courts for a particular position that has developed in Caribbean jurisdictions. So this is not something that we are going somewhere else to import. And we have had some great jurists who've contributed to where we are today. So, it's easy to blame a foreigner. But we've had chief justices who have sat in the Privy Council, one of whom is Dame Joan Sawyer, the first female chief justice and first female president of the Court of Appeal of the Bahamas. One of the most prolific jurists in my lifetime. When I speak about what I'm speaking about, this is my life's work. I have sat at the feet of these people. I have watched them.
So what are you saying? That we can't do it part? You stick with the Privy Council, or?
I am saying to you that it isn't as simple as saying, let's get rid of the Privy Council. No. Because the Privy Council is saying to us, this is what you all have decided.
Yeah, but I mean the process. Once I know the process, what should be done, then I guess
that can happen. It isn't as easy as all of that as Jamaica and Trinidad have found out. But it is possible to be done.
Okay.
But what are you doing it for? Do you want, for instance, to have criminal appeals to the Caribbean Court of Justice? And if so, why? But you want to have commercial appeals to the Privy Council?
And if so, why?
And if so, why? Are you saying that we are somehow not clever enough to do commercial matters here, but clever enough to do criminal matters? What makes us that clever?
Well, I feel we can do two right here by ourselves without
But
going
I'm
there.
just saying to you that, but these are decisions. No, but that is the point that I'm making. These are decisions that you arrive at after an independent discussion as to the pros and cons of doing that. But you don't make that decision just because you are opposed to a particular decision making on one particular issue. which is not even a cross crime. This is just a sentencing issue in the case of murder.
I don't think you should sentence. I think you should hang him.
No,
That's it.
but I would.
May I, before you ask a question, sir, may I ask if you would allow Mr. Roll to ask that question, sir? Because you've had an opportunity. The gentleman is standing by. May I kindly ask? May I ask? Yes. No. May I ask you if you would allow him, please? Thank you very much. But before Mr. Roll, you ask, Mr. Moreno, if Pope Francis was sitting before you and he said on World Peace Day, New Year's Day, quote, I also ask for a firm commitment to respect for the dignity of human life from conception to natural death. Here I would like to once more propose a concrete gesture that I can help foster the culture of life, namely the elimination of the death penalty in all nations, end quote. What would you say to him that he doesn't obviously understand?
Nothing. I got down that road, Mr. Lloyd.
Mr. Roll?
Good evening, Stanley Roll, attorney at law. I have two questions, and then the other name said something that raises the point for me when I was young. For those against capital punishment in the Bahamas, the way it is done, if the method of execution was more humane, tell me, would it change your view?
You're directing that in somebody in particular?
To those who are opposing the death penalty.
Ms. Spindamaki?
No, it does not change my view.
It wouldn't change your view if it was more humane.
My view is not because of the method of the death sentence. It's because of again, I reiterate, the margin of error and the fact that life should be preserved. So no, that does not change my view.
Nor does it change my view, but what I wanted to say is that the issue, as I have defined it, is not one of do you support the death penalty or not. It is a more sophisticated question. It is this. If the death penalty is to be the subject of a judicial discretion, once that discretion is properly exercised, the application of the death penalty would apply. So I'm not opposed in a blanket way to the death penalty. But what I'm saying is it is subject to the imposition of a judicial analysis of whether that sentence should be imposed or not.
Yes. My next question is the death penalty justice? And if it is, to whom? For whom?
So my view as a proponent is that it is justice for the victim's family. I've heard other proponents, when they speak, say it's also justice for society, who has influenced the law of the land to be that if you kill and you commit an act that they consider to be the worst of the worst, that it is what the society has deemed and influenced their politicians to pass and legislate as the law of the land. So I do believe it is justice for the victim and the victim's family, first and foremost.
So I will tell you this, and then I will add my point to this. When I was about 9 or 10, walking to NCA, I walked past Abundant Life Road, and there was some man from the prison putting 3 rough plywood coffin-like boxes in the ground. And I looked at it. There was no one crying. There was no one there but men putting these 3 boxes in the ground. So when I went home and I asked my father about it, he told me they were persons who were just hung that morning at the prison, and that's where they buried them. It was that incident that caused me to dislike
the hanging, because there was no one there to even sing a song, because I've been a couple of funerals when I was small, sing a song, or there was no crying, there was no females, like a mother or a granny. Grandpapa wasn't even there. That disturbed me.
And it should have disturbed you. That is a normal, natural reaction to the cheapening of life.
That is why I don't like
Even
hanging.
I've been to funerals, and I've listened to priests speak about adultery and the sins of the flesh, and I would be laughing to myself, well, why he choose this moment when he's gone to start talking bad about this guy? But it is the fact that we as sinners are able in a funeral service to give thanks to those things about our fallen fellow sinners that we regard as valuable. It's a tribute to God. What you witnessed was the complete removal of the humanity associated with those condemned men. And that is sad.
Ladies and gentlemen, we are pushing hard against 9 o'clock. And I have been advised that we want to wrap up within minutes, please. So we have two additional persons. Could we ask your questions somewhat quickly?
Yeah, Mr. Gomez, just to the...
Just no comments, sir.
No,
Please, could you ask the question?
The question is that the government, when it comes to the Privy Council, I believe that the appeal court here in the Bahamas can deal with the criminal side because of what the Bahamian people believe in capital punishment, and the civil side allow the Privy Council to deal with the
Well,
civil
obviously
side.
you didn't hear Mr. Gomez's response.
That can happen.
I think I've
There's
done
no
that.
hard thing about that.
Yeah.
Anyway.
Yes, sir. Question, please.
My name is Felton Cox.
Oh, yeah.
I have to distill what I'm thinking because I heard a lot of stuff. Let me approach my introduction by saying this. I watch when there's a question. When that question arises, it's usually from the elite part of the society. And usually, the local people doesn't have very much to say, except agree that it is treason, and treason is carried out. And there's no significant disturbance when it comes to treason, when it comes to capital punishment, where there's an abundant case of a man, and there's evidence abundant that this man raped a little girl, killed her. Your society, this society, the Bahamas society, has already agreed that capital punishment is for us, this society. Now, I'm not going to tell you what has happened before. You know what happened. This society has agreed. We have had a referendum on that subject matter. And technically, this society has said, yes, this society, not another country, this society has said that via referendum. I was here, and I voted yes. And this society voted yes. Now, I'm going to tell you something, folks. If we tell the government that when you have a situation where a man has raped a little girl and killed her, we will not sit here silently and allow that to be the rule. Now I heard the young lady use some information with respect to statistics. Let me just say this to you. The statistics you have quoted is not on an even keel. Let me explain what I mean. You said the following year there was a 53% increase in murder.
Just to interject, I said the same year, right after the hanging, there was a 52.53%.
Okay, well, I'm quoting you.
So what that indicates to me,
I'm quoting you correctly then. If there's a 350, that's not a even keel on which to make a judgment like that. When you're making statistical data, there should be an even keel on which to make that data. That's only letting you know what the result was the following year.
as I would have indicated, is that it fluctuates up and down throughout the year. So there's an uptick in some years, and then again there's a downward trend. And I did indicate the same.
It does not suggest that in one year you have good people and another year you have bad people.
What it suggests,
Yes.
sir, respectfully, is that it is not a deterrent. And that is the only point that I'm trying to drive home. It is not a deterrent.
Yes, but...
Because if you have someone being hung on January 6th of 2000, and you have a 52.53% uptick, clearly that has no bearing on a deterrent whatsoever.
As far as your statistical data is concerned, but this country has already said we wanted hanging.
So, Mr. Cox,
yes.
Mr. Cox, what's the question, sir? Because as I indicated, folks, we need to kind of close up shop.
Yes.
We have folks waiting to what's the question, sir?
My question is, if your country and your countrymen has voted to maintain hanging, would you support your country or would you go against your country? That's my question to you.
Thank you, sir. Question, sir? Thank you.
No answer.
There they are.
Three questions.
Sorry, just 1 second before you ask. So just to respond to Mr. Cox, I personally would say that I support the law of the land. And I think that's what my presentation was. And I think everybody's position is, Mr. Gomez spoke for himself. It's not that he's opposed to it, but he indicated his position. Another friend to my left is opposed to it vehemently, correct? Correct. As well as our guest this evening is also opposed to it vehemently.
We are in a democracy. I spoke about the value that I place on Article 1, which establishes that we are a democratic state. If we vote for a particular law, and the majority of us have carried the day, I will abide by the law. That does not mean that I will give up my right to be critical of that decision. So when you say support only means that I will obey the law. It doesn't mean that I will defend that decision other than through obedience of it. So I hope I'm clear on that.
Thank you very much. So, your question?
I have three questions, but the first two are like a yes and no. But the murder count that was mentioned and compared, I felt like the scope was a bit too small, so I actually did research up on my phone. But from 1990 to 2000, now on average, about 50 people killed a year. I think the last 2 years it was like 60 something, 74, like we said in 2000. But it was well below 50. On average.
Could you speak up a little bit first, please?
Sorry. But the year following that hanging, it dropped to 43, and then it continued on that trend of like 50s until 2006, and then after that, it increased again. So from 2014 to now, it's like 100 murders a year. So I just feel like that. I don't know. The numbers don't really support the opposition in that way. But is recidivism not a high enough standard? And do you think that appointed persons couldn't efficiently draft the bill to alleviate all of the procedural concerns mentioned, and if not, why not? That's for anybody.
Could you repeat that?
Oh, sorry. Is recidivism not a high enough standard already? And do you not think that a board of appointed persons could efficiently draft something to alleviate the procedural issues that anyone had brought up earlier? Is there no middle ground? Is there just, no death penalty? Was that clear? Do you need me to elaborate?
The law itself sets out that if a person has been convicted of murder before, whether in the Bahamas or outside the Bahamas, which is even wider than most inquiries go, the court has the ability to categorize that particular instance as being the worst of the worst. However, it is the judicial discretion is to be exercised not as some arid putting something in a box, and because it fits, you then classify it as the extreme case. You have to actually go into the details of the matter, and this is what is taught by Ernest Lockhart and the Crown. So we already have a process. The question that really is being presented to the public is whether that process is so foul that we should abandon it and replace it with a mandatory position, which doesn't give any discretion to the court. And it is that argument that I am opposed to. And I believe from the consensus, even Mr. Henfield speaks to circumstances where the death penalty would not be imposed on a child, on a person who is insane. Even when we were of the mistaken view that the penal code created a mandatory death penalty, and I think that was Storm in Bowen Davis, which preceded Maxo Tito. I worked with you. Even in those cases, you couldn't hang a person who was sick. So if the hanging was to take place today and you had the flu, they put it off until you got better. It is the craziest of things. You can't kill a sick man. So there were any number of nuances that prevented the so-called mandatory hanging from being executed on a particular day or on a particular person because of whatever reason.
Yeah. The second question, sir? You had a question?
I asked all three at the same time.
Sorry?
I already asked all three.
Okay, sir. Appreciate it. But Mr. Gomez, when judges themselves, or publicly and privately, said that they didn't feel that the legislature should be hamstringing them by taking away their discretion.
Well, the question is whether there is any jurisdiction that the court is vested with that is a feature of the separation of powers doctrine.
Perfect. Question, sir?
Good night, all.
And may I ask you respectfully, could this be the last question? Because we have to kind of close up.
My name is Brian Bastian. I'm a criminal defense attorney, associate murder seal and code. And my question is for Mr. Henfield. Mr. Henfield,
Sebastian, speak up into the microphone.
Why do you think that the death penalty would be a deterrent when statistics speaks otherwise?
Okay. Which statistics are you referring to, local or international?
Local.
Okay. Can you share those statistics?
Well, Ms.
Let me explain, let me say why, rather than put you through that. This is probably, there are several criminal defense attorneys in here tonight for all of you listening. When Stanley Rose spoke up there, when I walked away from criminal law at my uncle's firm, which is Willie Moss, Stanley Rose was walking the door. Probably one of the most impressive criminal defense attorneys I know, and this is another one standing right here. So no need to feel like he and I have any issue. I have the utmost respect for him. In my experience, in the 10 years that I've been a criminal defense attorney, I only represented murderers, armed robbers, rapists, drug traffickers, persons, gun possessed, accused, sorry. And I've had the experience of seeing people in my experience. I've been a lawyer since 2003. And I can recall seeing persons start out as just petty thieves, won their case, and the next thing you know, he's a gun tote, and I've seen the escalation. I then moved into activism, as some of you may know, back in 2015, working in a community from Blue Hill Road to Adelaide, 55,000 people according to the police station in Carmichael. And we came up with this plan back in 2015 that we would do a generational approach to address this crime, undereducation, and poverty in the community. And I've had the experience of meeting so many people because the community was so big. So you have an event, and in 1 month you interact with 3,000 people in the community, from Blue Hill Road, Carmichael section, to Adelaide. When you speak to these young men and ask, what do you want to do? And to hear a young man say, my role model is someone in his community who he knows has killed 12 people. I was a criminal defense attorney. I'm now operating as an activist, and I'm seeing a murderer has influenced men in the community, young men, to also want to be murderers, who don't see the value in life, but they're going to make $3,000. With $3,000 in that day and time, they could buy a bike called a 650. They can go to Fish Fry and buy a couple of bottles of beers for their friends. So my experience has taught me that it is a deterrent for the people I have interacted with. Your interaction with people may be different, and I can respect that. But I can tell you from my personal experience, having been a criminal defense attorney, having been a community activist now for 9 years and working with the young men charged, accused, convicted, I've seen and heard people say they are fearful of being sentenced and hung. That's my experience. So that's why. So yes, there may be statistics that I don't see that proves that. I don't know of any survey where we have interviewed the young men in this country and said, if you were going to kill somebody and you knew on conviction you would be hung, would you do it? I don't know if that's statistic. But I know of my personal experience as a defense attorney, seeing the escalation of persons, and as a community activist for the last almost 10 years, and meeting thousands of people every year at these initiatives who would say to me, this is what they want to be or do in their life, and they don't fear the police. They fear losing their lives, though. Thank you.
Appreciate it. Thank you very much. Ladies and gentlemen, let me say thank you so much to our panelists. Would you kindly give them a round of applause? I consider this to be an extraordinarily beautiful evening, and I also would like to kindly ask the principal of the Eugene Dupuch Law School, Mrs. Galanis, to come and give the vote of thanks.
Good night, ladies and gentlemen. This has been indeed a wonderful evening. I'd like to, on behalf of my colleagues at the Bahamas Bar Association, to thank our esteemed panelists, Professor, I should get your name right? Zachla, Mr. Gomez, Mr. Henfield, Ms. Tai Pindamaki, and our moderator. And thank you, ladies and gentlemen, who are in this room, and those who are participating by virtual video live stream. It's clear from the discussion and the engagement that this is a matter that we have to continue to treat with. And those of us in the academy look at it daily in some form or fashion. Those of us who work in the space will continue to be looking at it. And so we invite your continued engagement when we reach out again. And again, just thank you all so much for your presence here. Thanks very much.
Thank you very much, and good evening.
Thank you.